Probation started last June of 2024. It was a 7-year deferred probation. Motion to revoke that unadjudicated probation has been filed. Looks like the primary two allegations are, one, that you have allegedly committed the offense of aggravated assault with a deadly weapon, June 19th of 2025, and also evading arrest or detention with a vehicle on that same date. The evading, has it not been filed or indicted? Okay.
Was it with a vehicle?
It was with a vehicle. That's at least what the administrative hearing says, but
I haven't seen anything about the evading.
I think
it was only the...
My recollection was that it was evading on foot. I'm happy to explore it.
That's okay. Let me look at this as well. And so I'm going to take judicial notice of the court's file in each case. The new alleged offense of aggravated assault has been indicted in cause number 25 DCCR 0902. There's a $200,000 bond set in that case, and there's no bond in the motion to adjudicate. Mr. Lewis has filed motions in each of those cases asking, one, that I set a bond in the motion and that I reduce that bond. In the new allegation, I'm printing out real quick the PC. I'm going to take judicial notice of that. Give me just a second to review it as well. Mr. Coleman has filed a response reply to those motions to reduce, and I have reviewed that as well. Give me just a second. It was on foot, yeah.
That's what I thought, Judge. It allegedly
Started on a bicycle.
Yeah, I don't know where they get the vehicle from.
Yeah, they wrote it wrong on the PC even. That's where it came from. All right, Mr. Lewis, do you wish to call your client?
No, ma'am. Just argument.
Okay, go ahead.
Judge, as far as with these motions, the motion to set bond, motion to adjudicate, of course, majority of this does deal with this new allegation. As far as the other conditions of probation Mr. Gillery had, it seems that he was doing well with that.
From the jump, this isn't just a probation hearing, it's a reckoning. Judge Raquel West has seen mercy fail before, and she knows what that means. But here's the question. When a man already given a second chance commits another violent crime, how far should compassion go before it becomes a liability?
He technically was not working at the time of the offense. He had basically a reduced workload. It was a layoff, but they have been called back to come back to work. He's trying to be able to bond out so he can get back to work, possibly even hire his own attorney, or at least be able to take care of his bills and things like that while we go through this process to take care of this case. So he definitely would like that opportunity, at least by having a bond set on with the MTRP. As far as the new case with the ag assault, understandably, it is will be considered a serious offense. We are asking for a reduction there, maybe in incorporating some bond conditions that may secure any of the court's concerns with any public or private safety for plain witness or the general public while we're dealing with this, which could include, of course, GPS monitoring with a curfew would allow him to be able to go work and be back home to at least be able to take care of these things. With his job, he would be able to afford the monitoring and GPS monitor. He does have some support, family support. His wife is here today and has been here each time before she would come to court. And so that's what we ask for, Judge. Just, if we can get a bond that is a little more reasonable than $200,000. A bond that high, a lot of bonds from the courts, it's hard. A lot of them won't even touch that amount.
So what is the status of the burglary of a vehicle in Hardin County from June 8th of this year? That's an allegation in the motion as well.
As far as I know, it hasn't been accepted or they've been going to court on that. My understanding. So the main issues that we were dealing with, of course, is what was here.
Well, that's obviously, that one is also important to me because that would be another.
By the midpoint, the defense paints Gillery as a man fighting both his mind and his mistakes, begging for a bond to rebuild his life. But when reports surface of erratic behavior, trespassing, and a terrified neighbor, the courtroom's mood turns grim. And as the judge weighs justice against mercy, a single decision will seal his fate and open the door to the next, more shocking case.
Felony allegation while he's on this probation. Let me see if the administrative hearing has any information on that. So when the administrative hearing...
Notice how defense counsel builds the narrative job loss, family support, rehabilitation. It's the human story of a defendant trying to appear redeemable. But judges weigh more than sympathy, they weigh risk. And when the words aggravated assault with a deadly weapon appear on the file, every plea for leniency gets a little heavier.
Hearings are scanned in. I've noticed that some of them, it'll say see attached narrative or PC or something, and those are not always scanned in.
Are you looking at the court copy? It'll say court copy.
Okay, so the court copy should
Court
have
copy,
it.
'cause, it's not tablet.
Gotcha.
Yeah.
No, that's perfect. That's what I needed. Give me a second. I'm gonna print this out because this is... So, for the record, I'm taking judicial notice again of all of the court's file attached to the administrative hearing, which was dated June 16th, 2025, which is previous to a second one that was filed with regard to the new aggravated assault case. This one includes violation that he allegedly committed the offense of burglary of vehicle in Hardin County and failed to report his arrest to his probation officer, and then GED, community service, and some things like that. Attached to it is the narrative from the Hardin County officer. Let me read that, and I'll give you both an opportunity if you would like. So this is allegedly a neighbor where the allegation is that Mr. Gillery got in their car, tried to start it and leave, that they confronted him, that he got out, walking up and down the driveway between the trailers, quote, freaking out, striking the trailers in his own vehicle. The officer also noticed kind of some erratic behavior, felt like he was under the influence of some type of intoxicant, which he denied, but it sounds like there was something going on.
And Judge, if I may, speaking with him, he said this was an episode where he was under some type of psychosis, dealing with mental health, and checked himself in for treatment shortly after.
All right, so obviously I need that information because I don't feel like if that's going on that it would be in the best interest of our community to have a bond at this time. If there's something going on, then potentially we need to have some type of evaluation done ourselves to find out what that is and get that information to me. Based on all of the allegations in the motion as alleged, the burglary of a vehicle, the new aggravated assault with a deadly weapon, and the fact that he's already on probation for unlawful...
And that right there is the turning point. The neighbor's statement paints a picture of chaos. Gillery freaking out, striking cars, wandering in a haze. Defense calls it psychosis. The court calls it danger. So, what happens when mental illness collides with criminal accountability? Should psychosis excuse violence or explain it?
Possession of a firearm by a felon, which means he's already a felon in that burglary of a habitation case, I believe. That was a conviction. I'm going to find, based on all of that information, under 17.15, as well as the Constitution, that I can deny bond in the appropriate circumstances. And at this time, in cause number 22-40982, I am going to deny setting a bond in that case. And I'm going to deny the request to reduce the bond in cause number 25 DCCR 0902. And if you will get any information gathered together with regard to any mental issues, obviously that could go into play once we get to whatever point we do on what I'm going to do with the probation in the new case, and potentially for Mr. Coleman as well. If you feel like there's an issue with competency, let me know. It doesn't sound like that's the issue, but if so, just let me know. We'll get a someone out there to see him as quickly as possible.
No problem.
All right, you can go back with the bailiff. Good morning. Are you Kaylin Welcome? And Mr. Parker, will your client waive the formal reading of the indictment? Mr. Welcome, in cause number 25, DCCR 1156, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from July 9th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Welcome is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with that agreement to a term of 7 years in the Institutional Division of the Texas Department of Corrections.
And just like that, the hammer drops. Bond denied. 2 words that change everything. For Gillery, it's not just jail time. It's the system officially giving up on his redemption arc. But then comes Kane Welcome, stepping up like a mirror image. No arguments, no pleas, just guilt and acceptance. One man clinging to hope, another surrendering to consequence. Which one, do you think, found peace?
There is a finding of a deadly weapon in that case. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker, okay? Good luck to you, sir. You can go back with the bailiff.
The hearing begins quietly. Leonard Gillery, on a 7-year deferred probation for firearm possession, now stands accused of aggravated assault with a deadly weapon and evading arrest. His attorney pleads for relief, a lower bond, a chance to work again, to pay bills, to stand by his wife who sits faithfully in the courtroom. He insists Leonard had been doing well, holding down a job until layoffs hit, that this arrest was an exception, not a pattern. But the prosecution's file tells another story. A burglary of a vehicle, erratic outbursts, and neighbors watching in fear as Leonard struck cars and trailers in a frenzy. Officers described him as freaking out, possibly under an intoxicant. His lawyer